On February 18, 1895, a porter at London's Albemarle Club handed Oscar Wilde an envelope. Inside was a calling card left days earlier by John Sholto Douglas, the 9th Marquess of Queensberry. Scrawled across the back, accusing Wilde of posing as what the Marquess, a famously poor speller, rendered as a somnamite. Wilde had 2 plays running simultaneously in the West End that month. He was the most famous writer in England. He was also locked in a years-long, increasingly hostile feud with Queensberry, whose son, Lord Alfred Douglas, was Wilde's close companion. Queensberry had hired private detectives, threatened hotel managers, and confronted Wilde directly on more than one occasion. The calling card was the culmination of all of it, finally committed to paper in a way that could not be unsaid. Most of Wilde's friends urged him to ignore it. Bosie pushed in the opposite direction, encouraging Wilde to sue his father for criminal libel. Wilde, against the advice of nearly everyone except the one person whose advice mattered most to him, agreed. It was, by every measure history has applied to it since, a catastrophic decision. The libel trial, Regina, on the prosecution of Oscar Wilde versus John Douglas, Marquess of Queensberry, opened on April 3, 1895, at the Old Bailey, before Mr. Justice Collins. Wilde's barrister, Sir Edward Clarke, represented him without charging a fee, a gesture of personal loyalty rather than legal strategy. Queensberry's defense fell to Edward Carson, a fellow Dubliner who had attended Trinity College alongside Wilde decades earlier, and who now built his entire case on a single legal maneuver. Under British libel law, Queensberry could defeat the charge entirely if his lawyers could prove the original accusation was true, and that publishing it served the public good. Carson did not need to prove Wilde guilty of any specific criminal act to win. He needed only to convince a jury that the accusation was substantially accurate. He began with the writing. Wilde's letters to Bosie, intimate and effusive, even by the standards of Victorian male friendship, were read aloud in open court. Passages from the picture of Dorian Gray were quoted directly to the jury as evidence of the kind of mind capable of writing such letters in the first place. Wilde, given the chance to defend his own work under oath, performed beautifully. Asked whether a particular line in the novel expressed his own views, he offered the kind of polished, paradoxical answer that had built his entire career, insisting that art existed entirely outside the reach of ordinary morality. The courtroom laughed. The jury, by most contemporary accounts, was less charmed than amused. Then Carson stopped asking about books. He began naming young men, specific names, specific dates, specific hotels. Edward Shelley, Alfred Wood, Charles Parker. Each one, Carson announced, would be called to testify in detail about encounters with Wilde, encounters Queensberry's investigators had spent months documenting, and in some cases, paying witnesses to describe. Wilde was questioned about his age relative to these men, about gifts he had given them, about a kiss he denied giving to one servant boy on the grounds. He told the court that the boy was, in his own words, unfortunately, extremely ugly. The room that had laughed at his wit 20 minutes earlier went silent. That evening, Clarke met privately with Wilde and delivered the assessment that ended the case before Carson ever called a single witness. The libel suit could not be won. Worse, continuing it risked handing the prosecution a complete roadmap directly into a criminal case against Wilde himself. The next morning, April 5th, Clarke withdrew the prosecution entirely. The judge directed the jury to return a verdict of not guilty for Queensberry. Wilde, having sued for libel and lost before the defense even opened its case, was now legally liable for Queensberry's court costs, a debt that would help bankrupt him within weeks. It was, in itself, already a disaster. It was about to become something far worse. The moment Clarke withdrew the libel prosecution, Queensberry's legal team handed their entire case file directly to the police. A warrant for Wilde's arrest on charges of gross indecency began moving through the system almost immediately. The magistrate, John Bridge, deliberately delayed issuing it, a quiet act of mercy that gave Wilde a window to leave. Friends begged him to take the boat train to France that same evening. Wilde stayed. He waited at the Cadogan Hotel, drinking wine with Bosie while the warrant was finalized, and was formally arrested there on April 6, 1895. His first criminal trial, Regina versus Wilde, opened on April 26th at the Old Bailey. He was charged jointly with Alfred Taylor, accused of procuring young men, and pleaded not guilty to 25 counts. The evidence largely repeated what Carson had already assembled for the libel case. Hotel staff described stained sheets. Young men described gifts, dinners, and late-night visits. It was during this trial that the prosecution read aloud a single line from a poem written by Bosie, titled Two Loves. The line read, "I am the love that dare not speak its name." What Wilde delivered in response was not a denial. It was, by all accounts, extraordinary courtroom oratory. He described the phrase as referring to a great affection between an older man and a younger one, intellectual rather than carnal, comparing it to David and Jonathan, to Plato, to the sonnets of Michelangelo and Shakespeare. He called it beautiful, fine, the noblest form of affection that exists, deep and spiritual and pure and perfect, misunderstood by a world that mocked what it could not comprehend. The gallery applauded. Some accounts described genuine cheering. It did not produce an acquittal, but it produced something almost as significant. After days of deliberation, the jury could not agree. They could not agree on a verdict for most of the charges against Wilde. On May 1st, 1895, the judge declared a hung jury. He ordered a retrial. Wilde, remarkably, was granted bail in the interim, a small mercy. This allowed him a brief window of freedom before everything ended completely. The Crown was not finished. The hung jury embarrassed the prosecution badly enough. The Solicitor General himself, Sir Frank Lockwood, took the unusual step of personally overseeing the second criminal trial, an almost unprecedented level of direct government involvement in a single case. The message was unmistakable. This time, the Crown intended to win. The second criminal trial opened on May 20, 1895, before Mr. Justice Wills. The prosecution made one critical tactical change. Rather than trying Wilde and Taylor together again, the cases were separated, and Taylor was tried first. He was convicted quickly. By the time Wilde's case reached the same jury pool days later, the public and the court already understood. They understood that the man accused alongside him had already been found guilty of the underlying conduct. The evidence was substantially the same evidence that had produced a hung jury weeks earlier. The outcome was not. On May 25, 1895, the jury found Oscar Wilde guilty on the majority of the counts against him. Justice Wills did not hide his contempt. He described the case as the worst he had ever been called to try. He imposed the maximum sentence, 2 years of imprisonment with hard labor. Wilde attempted to speak, but was cut off before he could finish a single sentence. He was led from the courtroom, his celebrated life now irrevocably altered. Transported first to Newgate Prison, a grim symbol of Victorian justice. Through a series of transfers, he eventually reached Reading Jail by November. There, he would remain for the rest of his sentence, his world confined. It had taken 3 trials, one by Wilde's own choice, against all advice, to convert the most celebrated writer in England into a convicted criminal, serving the harshest penalty the law could impose. The calling card that started it all contained fewer than 10 words. What those words triggered took less than 4 months from mourning to prison. It permanently ended the life he had built before any of it began. In 2017, the British government issued Wilde a posthumous pardon. Under a law covering historical convictions for offenses no longer considered crimes, it arrived 122 years too late to change anything that happened to him in 1895. A century after the conviction had already finished destroying everything it touched.